They don't have the numbers in a Republican majority Congress, they lack the executive firepower of the presidency, and the possibility they'll get reinforcements at the ballot box is 14 months away. In politics, an eternity. As a result, liberals alarmed at President Donald Trump's deeply conservative agenda, and frustrated by the GOP lawmakers paving his way, have repeatedly deployed the most powerful weapon left in their depleted political arsenal, the federal courts. Since, literally, the day Trump took office in January, progressive organizations like the ACLU and good government groups such as Committee for Responsible Ethics in Washington, the so-called Resistance, have confronted Trump through a flurry of lawsuits and legal actions, filed in U.S. courts from Hawaii to the nation's capital. The issues span the gamut of Trump's 9-month presidency, his decision not to sell his real estate and business empire to avoid a conflict of interest, his executive order banning immigrants from Muslim-majority countries, his decisions banning transgender volunteers from serving in the military. All three, and several more Trump decisions, have been challenged. Although nearly all of the suits against the president are still working their way through the court system, the barrage of litigation has slowed some, but not all, of Trump's more contentious initiatives. The biggest win for the left so far has been an appellate court injunction against Trump's travel ban, which was the subject of a series of high-profile district and appellate court hearings in February and March. The government's appeal of that injunction is still pending before the Supreme Court. The opposition through litigation strategy continued this week, when Trump announced he was phasing out an Obama-era immigration program that protected young adults who were brought to the U.S. illegally by their parents as small children from being deported. Within hours, advocates for the Dreamers sued the White House in federal court in New York. What's the alternative? Says Deborah Rode, a law professor and director of Stanford University's Center on the Legal Profession. The courts are all we've got at the moment. So far, so good, says Elliot Mintzberg, a senior fellow with People for the American Way, a liberal public interest group. When you look at the decisions we've seen so far, even Republican-appointed judges have ruled against the extreme actions of President Trump, he says. It's absolutely critical, he says, for the courts to function as intended, a check on executive power and potential Republican legislative overreach. Yet even progressive and civil rights advocates acknowledge that using the courts as leverage against Trump has some major drawbacks. Trump may be unpopular, but he's still the president, the courts often defer to his executive power, and judges are mandated to rule on the legal merits of a case, not involve themselves in partisan politics. Courts have historically demurred to the political process, says Jonathan Turley, a Supreme Court analyst and constitutional law professor at George Washington University. Federal judges, he says, have a deep resistance historically and legally to cases that are brought as an extension of politics. Litigation in the United States is not supposed to be politics by other means. More storm clouds for the left, because Trump is the nation's chief executive. Not every White House policy can be opposed on legal grounds, especially if Congress tailors a law or policy to avoid a court challenge. Meanwhile, Senate Republicans working with Trump are racing to fill the more than 100 federal court vacancies Obama had to leave behind. And the conservative majority Supreme Court, including Justice Neil Gorsuch, Trump's first high court nominee, will probably have the last word on many of the lawsuits. For liberals, there is a certain cathartic value to filing lawsuits like the deferred action against childhood arrivals, lawsuits to fight back against Trump, says Turley. But it comes at a price. It undermines the credibility of other lawsuits that are filed on more substantive legal grounds, and it can also offer false hope to people who are subject to Trump's initiatives. Though the strategy has been in play for 7 months, there isn't much new about suing the government or using the courts to push for political change. The Supreme Court struck down separate but equal racial discrimination in 1954 after its landmark ruling in Brown v. Board of Education, a case which began as a lawsuit against the Topeka, Kansas, school district. Gays and lesbians won the right to marry when a gay man sued the Ohio Department of Health. The Supreme Court took the case and made a ruling in 2015. Nor is it exclusively a tactic for the left. During the last administration, attorneys general from 27 Republican-dominated states used lawsuits to derail former President Barack Obama's immigration,